My name is Tom Breedlove, and I'm very pleased to introduce one of our lecturers today, Mr. Sid Kess. Sid has won, he's an attorney and a CPA and has won every distinguished award you can possibly imagine. He's a living legend, and he is here with us today to talk about major changes in the household employment industry and the impact of some of the new legislation and the impact it will have on your families and your practices. So again, my name is Tom Breedlove. I am director of Care.com HomePay provided by Breedlove, and we're very pleased that you were able to attend today. I'm now going to turn it over to Sid.
Thank you, Tom, and I'm honored to be with you. As an attorney and a CPA, I find that most professionals like myself have never had any formal training when it comes to payroll taxes. And those of you who work in trust departments or financial planners, I don't believe any of you have had any formal training. Both in accounting and law school and the LLM program, I never had in any of my tax courses any exposure to the area of payroll taxes. And yet, most practitioners, such as yourself, myself, find that a knowledge of this area is critical both in your personal life as well as for your clients. Let me give you a few examples in my own personal life. My Aunt Jen passed away at age 101. She was terrific. She kept her records and she handled everything on her own. But before going to a nursing home, she needed a caretaker. And all kinds of records had to be kept. It was just too much for her. And ultimately, she went to the nursing home. Betty, my long-term friend, developed dementia and the early stages of Alzheimer's. She needed a homemaker to take care of her. Lydia, a top corporate tax lawyer who put together some of the biggest deals in the country, had a nanny for her children. And she's a full-time lawyer. She was so busy, and she needed help for the children. And the work that was required was a disaster, keeping the records and all those returns that she had to file for the nanny. Martha, my French teacher, was alone, and she reached her 90s. She needed a companion. Once again, the paperwork and the handling of the caretaker was too much for her. Now, in your own family or in your client's family, how to handle household help is frequently overlooked or mishandled. And with an aging population, senior care needs are growing rapidly. Understanding the payroll rules as well as the new legislative developments that Tom Breedlove is going to discuss with us in detail today is more important than ever. And if you fail to comply with these new tax and labor law rules, it can prove to be very costly. Tom is going to help us guide us through the complex household employment issues. We, as advisors, need to be proactive. Our clients can't wait until tax time or neglect to act or fail to comply with the rules. They will have already made a number of expensive and time-consuming mistakes if they don't act properly. And as advisors, we need to help them understand that it's much cheaper, easier, and less risky to handle this directly during the hiring process. Next tax season is too late. Household employment is quite different than commercial employment. The payroll process is different. In addition to that, you should realize that the tax reporting process is a lot different. The labor laws are different. The family needs are different than the commercial enterprise. So when you're helping clients in this area, I advise you to steer them to a specialist in household employment. A firm like Care.com HomePay does this all day, every day, and is set up to provide expert support to your clients. And at this time, it gives me great pleasure to bring back Tom Breedlove, the director of Care.com HomePay, who's going to talk to us on the major changes in household employment. And Tom is just the person to do this. He has 30 years of business experience, including more than a decade as the executive team of Breedlove and Associates, now Care.com HomePay. It's the nation's leading household employment specialist. He is co-author of the Household Employers Financial, Legal, and Human Resource Guide. He's been an active speaker on this complex topic. And as director of Care.com HomePay, Tom is leader of a national service firm that's focused on delivering a comprehensive solution for busy families with care in the home, handling all the state and federal employer requirements related to payroll, wage reporting, tax remittance, labor law compliance, and tax agency correspondence. Tom holds a BBA in finance with a minor in accounting from the University of Texas. Tom, would you please take over?
Yeah, thank you, Sid. I appreciate that incredible introduction. The stories that you told are very touching and stories that we hear every day. And our goal in this webinar is really to arm you with enough information to make sure that your firm is absolved of any risk, number one, and number two, that you're adding value in your practice by helping families avoid risk in their household employment situation. So I really appreciate the introduction, Sid, and real quickly in the way of agenda, I'm going to begin with some of the new legislation that is really bringing the household employment industry out of the shadows. It's an industry that has been underground for many, many years, where the majority of workers have been paid illegally. And we're going to talk about some of the new legislation that's changing that rapidly. So it's going to become an issue that you will probably confront in your practice more and more in the coming years. Secondly, I'm going to talk a little bit about some of the common employment mistakes that we see every day. These would be the red flag topics for you to have, you and the advisors in your firm to be aware of, so that when you're working with families, you can help them mitigate risk. And then I'm going to talk a little bit about some of the ways that you can help your family save money, which is always a good place for you and your practice to be, is helping families to reduce cost in this area. So I want to share some tips there. And then we have a host of free resources I want to make you aware of as well, and we'll end with some questions after that. Okay, let's start with the new legislation. There really are three forces kind of coming together that are I think conspiring to make this to bring this industry into the light of day. The first one is the Domestic Worker Bill of Rights. This legislation began in New York in 2010, so it passed a couple of years ago in New York, and then California, Hawaii have both passed bills, and they've been those are now enacted in both of those states. Massachusetts has passed a bill which will be enacted in early 2015 in April. And then about a half a dozen other states have bills pending. And it's the legislation is important legislation in the sense that it has drawn an enormous media attention in those states, as well as raised awareness among the workers themselves as to what rights and protections they have under the law. Excuse me. And some
now, in other words, this is state legislation, Tom. It's not
yes,
a federal. It's not federal law.
That's right. Now, many of the federal laws that protect workers were created under the Fair Labor Standards Act back in 1938, and they are still on the books today. So the federal statutes have many of these protections in place, but what's happened recently is many of the states did not have anything in writing on their statutes that protected workers, and so they wanted to clarify the law in their state. And then also New York and California, really New York, California, Hawaii, and Massachusetts have all kind of added some new wrinkles to the legislation that the federal law had already provided. So it's essentially adding on some different complexities and nuances to the federal law. But as it's sweeping across the country, domestic workers are becoming emboldened with understanding their rights and their protections, and understanding what taxes mean to them and their long-term security. It's having done this now for more than 2 decades, we are constantly amazed that most workers and even most families don't really understand that our payroll tax system funds most of the worker benefits that we all enjoy, like Social Security, Medicare, disability, unemployment. All those benefits are really funded by the payroll tax system. So when a whole industry is paid underground, like the domestic industry has for so many years, it creates a real problem in terms of benefits, vital benefits for these workers as they age, or when they have an issue like becoming unemployed, they don't have ways to make ends meet. So it's a really important awareness campaign, if you will, that with this Domestic Workers Bill of Rights, as it's sweeping across the country. It's heightening awareness, so that I think your families are going to start to ask you questions about it, and it's important that you and your practice are kind of at the forefront of risk management in this area. The second piece of legislation that is having an impact is the Affordable Care Act, and a lot of people have questions about this because the employer mandate hasn't even kicked in, and in fact it's not even relevant for household employers because they have fewer than 50 employees.
When you're talking about the Affordable Care Act, you're referring to the health-led care, or the Obamacare legislation.
That's right. That is correct. So most of the provisions of the Affordable Care Act have to do with employer mandate, what they call the employer mandate to provide health insurance, and that doesn't apply to household employers. But what's happening is the worker on the individual mandate, which is one of the provisions, required every individual to have health insurance. And so many of the workers in the domestic worker industry, many workers don't have access to health insurance. And so when the legislation passed, they went to the federal or the state exchange and purchased a policy on the exchange. And the Affordable Care Act entitles those workers to subsidies if they're paid less than 4 times the poverty level. And of course it kind of phases out the more you make. Well, most people in the domestic worker industry fall within the subsidy and are entitled to sometimes up to $2,000 or $3,000 back at the end of the year. But the catch is that you have to have documented wages. So what we're anticipating is that in February or March, we're going to see a lot of workers approaching their families asking for a W-2 so that they can get their health care subsidy back from the federal government. So when that happens, we want to make sure that advisors are prepared for those questions that they may get from the families, because I do think it's going to be, just based on the number of folks who purchased health care through the exchange during the open enrollment last year, I do think we have a lot of domestic workers who are in this boat, and families are, if they've been paying illegally all year, they're going to have this question arise at the end of the year. So we want to make sure everyone's ready.
Well, they may want to advise the domestic worker of the need to get health care.
I'm sorry, could you repeat that question?
They may want to advise the worker that they're eligible for this kind of subsidy.
That's exactly right. It's if they're working with someone in this area, they might want to advise the worker. The penalties for next tax year become much steeper. You know, in 2014, the penalty was 1% of your income or $300, I believe it was, whichever is greater. And in 2015, so for the next tax year, it will be 2% of income or $600, whichever is greater. I believe those numbers are right, but don't quote me on that. But the 2% and the 1% are right. And so the point is, it's going to become a more a punitive issue for workers who don't have health insurance. And I'm going to talk a little bit more toward the back end of the presentation about some of the tax benefits of employers getting involved in the health insurance for their worker, because there are some tax breaks that kick in and help families and make it all more affordable for both parties. But just know that this legislation is driving a lot of awareness and a lot of need for documented wages. And then the third area of legislation that we'll talk a little bit more in depth in a few minutes is a repeal of what's called the companion care exemption. So those of you who work with a lot of senior care or families who have senior care needs may be familiar with the companion care exemption, which essentially allowed families or senior care agencies, if they were staffing a senior care need with a companion, they didn't have to pay overtime, and in some cases they didn't even have to pay minimum wage. So what's happened is the Department of Labor has repealed that and said that if it's a third-party worker, meaning a worker who is employed by a staffing firm or a senior care agency, then the worker would be entitled to overtime. But if that worker is employed directly by the family, then they would still be entitled to the companion care exemption and would not have to pay overtime. So I think what's going to happen here is that there's going to be kind of a gravitational pull for cost reasons. There's going to be a gravitational pull for families to become the direct employer of their senior caregiver, particularly in the case where she's a companion. So we'll talk about that a little bit more in a few slides. But those three things together are really changing the landscape for the household employment rule. Okay. Before we jump into some of the danger zone areas, I'm going to talk real quickly about the basics, just to make sure we're all on the same page. The household employment law is predominantly driven by IRS publication 926, and that publication defines a household employer as anyone who's paying someone in and around their home to perform duties, and if they have the right to control when the work is performed, how it's performed, or by whom it's performed, then they're a household employer. And if they pay that person $1,900 or more in a calendar year, then they've crossed the threshold that then requires them to take care of what the media has termed the nanny tax obligations. That term is a little bit of a misnomer because it actually applies to all domestic workers, not just nannies. But nevertheless, it's called nanny taxes. A lot of people know it as that, so we'll go with that. But when a family does cross that $1,900 threshold, they're required to withhold the payroll taxes from the employee's pay. And the payroll taxes on the federal side are Social Security and Medicare. And then in some states there are some state taxes as well that have to be withheld from the employee's pay. And then as employers, they also have to pay some employer taxes. So employers are required to match the Social Security and Medicare taxes. That's called the FICA match, or the employer match of FICA. And then they also have to pitch into the state and federal unemployment tax pool. So they pay a little bit in unemployment taxes, and then when their worker is unemployed, then the worker will pull funds from that pool. The good news for household employers is that when you pay legally, you're entitled to some dependent care tax breaks that can offset most of the cost of being an employer. These taxes that I mentioned here, they can be largely offset when you pay legally and you take advantage of the tax breaks, which I'll go into more detail in a few minutes. So that's the good news. Most people think this is going to be really, really expensive to pay legally, and the truth is that the tax breaks really change that so that it's, in some cases, families even come out ahead. We have a calculator on our site that helps you understand what your taxes are going to be as well as your tax breaks, and I can tell you that most families are very pleasantly surprised at the overall cost. It's just not nearly as high as they think. Then the rest of the obligations, the families are required to file state and federal employment tax returns throughout the year. And Sid, as you mentioned early in this in your introduction, if you wait till the end of the year, this is one of the major problem areas because the deadlines hit throughout the year. The state typically requires quarterly tax returns, and the federal dollars have to be remitted, or else you could be subject to underpayment penalties if you don't pay those taxes during the year. So it's one of the reasons why you really need to take care of it at the time of hire. And then the final obligation at the bottom of this screen is really what happens at the end of the year. And what happens there is the family has to provide the worker with a W-2 and then file a copy of the W-2 with the Social Security Administration so that the worker can get earnings credits that will provide income and medical coverage later in life when they retire. And then the final thing that they have to do is file what's called a Schedule H as in household. And this is where the household employment world merges with the personal income tax world. So the family files the Schedule H. They file it with their 1040 personal income tax return. The Schedule H actually shows all of their activity as a household employer and actually shows it as a liability. But what happens is then you offset that liability with all of the payments that you made during the year, and then it's really just becomes an accounting document for the government. But it's an important accounting document because you can't take the tax breaks that I mentioned before unless they have that Schedule H and all of the accounting document is closed, and it'll kick back the return. So very, very important to take care of these obligations correctly.
Tom, just for a moment, let's stop for a second and take all those situations I gave in my introduction. Aunt Jen, who's 101, or Betty, who has dementia, or Lydia, the busy Wall Street lawyer who has nanny for the children. They have to file all these different returns, and they're quarterly, federal, state. What does a company like Care.com HomePay do to help them avoid all this obligation?
Well, we take care of everything for the family. So we're accountable and totally comprehensive. We take care of all of the payroll calculations and tracking, and then we take care of all the tax returns and remittance of all the taxes. We take care of all the year-end filings. We also correspond with the tax agencies. So really families, when they come to a specialist like us, that we really take care of absolutely everything they need in the household employment world, including guidance on labor law issues, which is a good segue into our next slide.
The other point that I think is very important, it's a pain in the neck for a financial planner or for the trust officer or for the accountant or the lawyer to take care of each one of their clients' caretakers. And it's more costly for the client.
Yeah, it tends to be, most of we work with literally thousands of accountants and financial advisors and attorneys and trust managers, and I think the predominant response that we get is that this comes up fairly rarely in their practice, and it's highly, highly inefficient for them to try to process this and advise families on this, because the tax laws and the labor laws are so nuanced, depending on your situation, what kind of caregiver, what state you live in, how much you pay her. It's so nuanced and it's so difficult to keep up with when you're only doing 2 or 3 a year, that they feel like they have great liability when they get into that world, and like I said, it's just so inefficient to be handling payroll changes with the family, answering questions from the caregiver. It is, like you said, it's a very messy, pain in the neck kind of a thing to deal with, but it is important that it be dealt with correctly, which is really why we're here to try to make this easy for both the family and the practitioner. So let me jump now to some of we talked about the tax obligations, and I think a lot of folks understand that there are some tax obligations in the employment world. I think where we see an enormous amount of problems, though, is in the corresponding labor law obligations, because as I mentioned, and Sid mentioned, the labor laws are really different in the household employment world than they are in the commercial employment world. So household employers have a lot of work to do just to kind of understand what's required of them, and then make sure that they're not making any mistakes that could come back to haunt them, because most of these that I'm about to mention don't have any statute of limitations associated with them. So you could have a former worker come back 2, 3, 4, 5, 6 years later and file a wage dispute saying you didn't pay overtime, or you didn't do this correctly, you didn't provide pay stubs or whatever, and they will typically win that wage dispute. So families have exposure if they don't take care of these things correctly. So just quickly, I'm going to address a few of them. The first one is having some form of contract or wage notice. 19 states require the employer to put the conditions of employment down on paper for the worker, and there are stipulations in there that are really important. Number one, to make sure you have a good professional relationship, but number two, they do provide protection, and they do meet the requirements of the law to put it all in writing. Secondarily, and kind of related to that, is that the worker has the right, in most jurisdictions, has the right to detailed pay stubs to make sure that they're not getting bamboozled by fancy math games or something. So the employer has to provide a detailed pay stub that shows the wages for that particular pay period is broken down by hour. So you have to show hours worked, the rate per hour. If there are overtime hours, then the overtime rate has to be on there. The taxes withheld have to be on there, and not only for the current period, but for the year-to-date total. So exactly what you would probably see in a corporate type of pay stub. Those are the things that families are required to provide, which is, like Sid was saying before, is not easy for most families. They're not really equipped to spit out detailed pay stubs every pay period. So it's just another one of the little things that's required that we do handle at Care.com HomePay. Another labor law obligation is overtime standards have to be met, as well as minimum wage. So you need to know that in some there's a federal minimum wage, there's a state minimum wage, and in some places there's actually a municipal minimum wage, and the highest of the rates would apply. So if you live in San Francisco, you have to meet the San Francisco requirement as well as the California, as well as the federal, so you have to pay the highest of the three. And that's just one example. But it's important for you to understand that it does vary by state and even by city in some cases. So we help families understand all that, keep track of it. And I'm going to talk a little bit more about overtime, because overtime has some similar state overlay to the federal government, and we'll talk about that in more detail in a minute. Expense reimbursement and mileage have to be taken care of properly and itemized on the pay stub. In 30 states, workers' compensation insurance is required, and in 5 states, disability is required. We'll talk about those a little bit more in a minute. And then in some jurisdictions, paid time off is required, although I will say that generally speaking, household employers are not required to offer paid time off, paid vacation, or paid sick leave, but there are a few places that it is required, so you really need to know the nuances for your state. Okay, now I'm going to talk a little bit about some of the mistakes that we see every day that can really be expensive for families, and I think this is an area where if you'll pay attention to some of these areas and kind of create a red flag in your mind, and let us help you help your families avoid these mistakes. The first one is worker misclassification. As I said before, the IRS has a definition of who's a household employer, and that corresponds with then the question about, is this worker my employee or can I call her an independent contractor or self-employed? And I can tell you that we pay attention to parent forums, and we talk to families all the time who come to us with a lot of confusion in this area, and a very good chance that they have been misguided on this by a layperson, a friend, or a neighbor who says, oh, just give her a 1099 and then you don't have to worry about the reporting obligations or the taxes. But what everyone needs to know is that the IRS has ruled on this, and in virtually all cases, a domestic worker will be considered an employee, not an independent contractor. So if you give her a 1099 or call her an independent contractor, there's a good chance that you're going to be subject to some very expensive penalties around, because they view this as tax evasion because the employer taxes that aren't paid, such as unemployment. So they really want one throat to choke, and they want the family to be the employer. So we petition, there's a form called SS8 that you can petition to the IRS for a ruling, and I can tell you that we've done dozens and dozens of scenarios, and they always come back, she should be your employee. And as I mentioned, in addition to the tax evasion charges that could be levied against you, there's also penalties and interest. And if you remember me saying that a family has to withhold the payroll taxes like Social Security and Medicare from the employee's pay, well, this is an example. If you don't withhold the employee's FICA taxes, then you as an employer are obligated to pay them. So that just adds even more expense to this problem. If you've misclassified your worker, then you haven't withheld the taxes properly, and you as an employer then owe them. And then I also wanted to make a quick note that the Department of Labor and the IRS have announced and teamed up recently to announce increased enforcement in this area, and they actually cited the household employment industry as a prime target because they see so much abuse in the household employment world. So it's kind of a warning to everyone that it doesn't matter what's in the contract, it doesn't matter how many hours she works or how much she's paid. It really comes down to who has the right to control the work. And the IRS is going to determine that most of the time the family has the right to control the work, and therefore they're an employer. So very, very important issue for you to help your families avoid. And the second one, that we've hit on a little bit already, is really just the whole issue behind waiting until tax time causes so many problems. If you take nothing away from this webinar except this, I'll be pleased. When families hear the word taxes, they think, I can deal with it at tax time, next February or March. I'll drop it on my accountant's desk, and it'll all be taken care of, and I'll be good. The problem is that this isn't really taxes. This is employment, And with any kind of employment situation, timing is everything, and you need to deal with it at the time of hire, or else you will probably have not withheld the proper taxes and then be subject to pay them yourself. You probably won't have made your quarterly payments to the state and the IRS, so you're probably going to have penalties there. You probably made labor law violations, so you're going to have problems there. You probably didn't provide a contract or employment agreement, didn't provide pay stubs. All those things that I mentioned a few minutes ago, chances are families will have major problems if they wait until the end of the year to deal with this. So if you can be proactive with your families and help them understand that this is important to deal with it immediately, you will have saved them an enormous amount of time and frustration. Obviously, we would love to have them as a client, but if they don't get help here, we want them to get help somewhere. So make sure that this is dealt with properly at the time of hire. And the third area that we see just an enormous number of mistakes here, it really it's always tough because usually the family is well-intentioned here, but since many of your clients will have a company of their own, there is a kind of a natural tendency to say, I'll just put my domestic worker on the company payroll. And a lot of times it's based on the idea that, well, this will be good, I'll get her benefits such as health insurance, and we'll throw her on there and it'll just make everything easy. But the problem is that businesses have access to a payroll tax deduction, so they're able to get a write-off on payroll expense, but the IRS has ruled that everyone on that payroll expense item has to be a direct contributor to the success of the business, and they have ruled that domestic employees are direct contributors to the success of the household, not the business. So if you put their payroll expense on your company tax return, you'll be taking an illegal tax deduction. So that's one issue. The second issue is that businesses are not allowed to report domestic worker wages on their tax return, except in the case of sole proprietorships and for-profit farms. So if your families have one of those two entities, they would be able to report the wages on their company tax return, but the payroll tax deduction issue could still come back to haunt them. So make sure that those two issues are dealt with. And then the third is an important sort of legal counsel here, and Sid could talk probably more about it, but the most attorneys would tell you that it's wise to keep the payroll separate for asset protection reasons. We had a case not too long ago where the family was named in a wage dispute, and the plaintiff's attorney found out that they were being paid through a very, very deep-pocketed corporation. And when he found that out, he sued the corporation and was able to get a judgment that was several times what he would have gotten from the family. So it's important to know from a legal liability standpoint as well. Another recent case that came up that was really heartbreaking for me was to hear the story of a doctor's office who had offered a nanny health insurance through their office health insurance plan, and she came down with cancer, was diagnosed with cancer, and had almost $100,000 worth of cancer treatments. And when the insurance company found out that she was a domestic worker, a nanny, they denied all claims and forced the doctor's office to actually have to pay all of the health insurance bills for that nanny. And they denied it under the premise that she was not, she should not have been an employee of the company and should not have been in their health insurance pool. She shouldn't have been in the risk pool. So they threw the book at the company there, and the company was forced to pay that $100,000. So it's just another lesson on why household payroll and company payroll really don't belong together. So make sure your families don't make that mistake. Okay, the fourth mistake that we see with great regularity is violations in the world of overtime. And I think that the problem here stems from the fact that most of your families are professional workers who are paid a salary at their office, and they could work 45 hours one week, 60 the next, and their pay doesn't fluctuate at all. So the mentality among the families is that salary equals no overtime. And they don't understand that the way the federal law is set up is that it really doesn't have anything to do with salary or hourly. What it has to do with is class of worker. And your families probably fall into the exempt category, so they're not entitled to overtime, but their caregiver falls into the non-exempt bucket. And as a protected worker under the federal statutes, she would be entitled to overtime for any hours over 40 in a 7-day work week. So it's important for you to help advise your families that they can offer a salary if they want to try to make it all convenient, but fixed salaries are illegal. So if the worker works extra hours one week, they have to pay her for those extra hours, and if the extra hours are over 40 in that week, then they have to pay her at time and a half for those extra hours. So really, really important, and as I mentioned before, there's no statute of limitations on overtime. So we probably see at least, we get one call a month probably from families who have been named in a wage dispute from a former employee from more than 2, 3, 4 years ago. And in many cases they say, well, she was paid 50, we paid her a salary, she worked 50 hours a week for us for 3 years, and we paid her a salary, and the judge in those cases basically takes the salary and calls them all regular time, and then says on top of that you have to then pay time and a half for the extra 10 hours every week for the last, for the time she was employed. So in most cases the penalties and the back taxes and the wages and everything, when you add it all up, we're talking tens of thousands of dollars that could have easily been avoided if they just would have been handled correctly at the time of hire. And related to overtime, I want to share a couple things that we get a lot of questions about. I want to make sure that everyone is aware of. One is we're seeing it more and more in the senior care world now. There's a statute in the federal books that is called the Federal 24-Hour Shift Law. And that law basically says that a worker can be, if she's working 24 hours around the clock, up to 8 hours of that time that she works, if it's sleep time, can be non-compensable. So what we're seeing families do now is kind of create 24-hour shifts where they might have a couple of workers on a team, and they alternate days, and then they're able to only pay them for 16 hours a day instead of 24, which can then greatly reduce the payroll expense. The only caveat there is that you have to have adequate sleeping facilities for the worker. She has to be able to sleep for at least 5 hours of continuous sleep. So if she's having to get up throughout the night every hour, then this little perk goes away. But if she's able to sleep and she agrees to it in writing, then families can structure their payroll so that we avoid some of the high cost of trying to have around-the-clock care. And then the second point on overtime that I want to just kind of add to what I mentioned before is this companion care exemption that I mentioned is being repealed, and that goes into effect January 1st, 2015. So effective January, if the worker is employed by a senior care firm, then they're considered a third-party caregiver, and they would then be entitled to overtime. But if the family hires directly, they could have that person be a companion, and they would not have to pay overtime to the worker. The only caveat that I want to bring up there is that when this exemption was repealed, they narrowed the definition of companion care and restricted it really to fellowship activities such as reading, watching TV, taking walks, things like that you would truly do to be there to provide companionship. But if the worker is if more than 20% of their time is spent on activities of daily living that would be more in the work category, such as meal prep and bathing and dressing, things like that, housekeeping, then the worker would not be considered a companion in that case. The worker would then be reclassified as a senior caregiver. So it's important for families that they're going to hear a lot about companion care exemption being repealed, and they may think automatically, well, I'll just make my senior caregiver a companion, and then I don't have to pay overtime. So we want to make sure that they don't have exposure from a lawsuit, down the road. Make sure that they truly are a companion, or else they would be entitled to overtime. Okay, the last of the common mistakes that we see is really the insurance products. There are two insurance products that are required in quite a few states. Workers' comp actually provides medical expenses and lost wages in the event that the worker has an injury or illness that is work-related. So it doesn't have to happen in the home. It could be in the car if they're driving, or it could be at the park, even if it's a nanny. It could be anywhere as long as it's work-related. Workers' comp would provide coverage for medical expenses and lost wages. And it's really important for families to understand that even where it's not required, we highly recommend it. And the reason we do is that if a worker were to get hurt, like I just mentioned, in a car wreck or fell down the steps or something like that, the family would be liable for the amount of the damages that would have been awarded in a workers' comp claim, even if it's not required in their state. So there's a lot of families have a false sense of security that if it's not required in their state, they don't have any liability. But the truth is, if that worker were to get hurt, the family would be the one who's on the hook for medical expenses and lost wages. So you can see that can be an enormous exposure for families. The medical expenses, the way they are these days, and of course any kind of long-term injury could put a worker out for months at a time. The family is now looking at maybe tens of thousands, maybe $100,000 worth of expenses that could have easily been prevented with a small workers' comp rider on their homeowner's insurance. So we highly recommend that families at least talk to their homeowner's agent about workers' comp, and feel free to call us or check our website if you're not sure whether it's required in your state. But we can help families understand that process. And in a similar vein, disability is an insurance policy that helps with lost wages. So it doesn't help with medical expenses, but it does help with lost wages if the worker is injured for any other reason besides work. And in the domestic industry, we see lots of situations where the worker gets pregnant and maybe it has bed rest or something for a few weeks, or is on maternity leave for 6 or 8 weeks. This disability would actually provide help for that worker and provide for lost wages, so that the family could then go hire a replacement worker and make sure that the worker can make ends meet while they're out. So two really important insurance products that can really make the difference between a great long-lasting relationship with their worker and an expensive problem if it's not done correctly.
Tom, there's one other common mistake. Mom comes home, has a stroke, and she comes home. Next door neighbor says, I've got a great caretaker. This woman was wonderful. She comes, you interview her for the job, and she says, I want my pay to be off the books.
Mm-hmm.
And you don't want to go through all the headache of all these returns that you're talking about. What mistake is made there?
Well, in that case, the family is essentially conspiring to commit tax fraud, which is a scary, scary way of saying that failure to report is really completely on, it's an obligation for the family. The onus is 100% on the family to abide by the law in this case. So if they let a worker talk them out of this, they're putting themselves at risk, and that's a dangerous situation to be in. So we usually just tell families, you know, let's run some numbers. Let's help you understand your obligations. Let's help the worker understand the benefits of having taxes withheld, because most workers don't understand that. And let's see if we can make the gap work between the net and the gross wages and make it all work out. And if it can't, then you as a family have to decide if you're willing to take that risk. But I think the Domestic Worker Bill of Rights and some of the other things that are happening in the industry, there are a lot of workers now who are willing to be paid on the books. And so I think it's a question of education, and it's a question of families understanding that, you know, they may have to search a little harder, but it's worth it to try to find someone who's willing to do it right, because they're the ones who are at risk, not the worker.
One more thought. We have to be careful of the immigration law. A lot of illegals are doing caretaker roles now.
Right.
In many areas.
It is.
I find they may be wonderful workers, but they're illegally allowed to. They're not allowed to work, and they're doing this.
That's right, and employers have the tough responsibility to provide a employment eligibility verification form, which is called I-9, and make sure that that worker is legal to work in the United States. And if she's not, then they have a choice to make, and that is, do I want to break the law and hire this person? If they do hire the person, or if she's been hired for many years and they don't want to let her go, I can tell you that the IRS and the Citizenship and Immigration Services have an agreement that they still want the employer to pay the employment taxes, even if that worker is illegal, and they won't kick anyone out of the country for being here illegally if they're paying their taxes. So it kind of comes down to, do you want to break one law or do you want to break two in that scenario? And we usually tell families, if you are going to hire illegally, at least follow all the employment law and report those wages. The other benefit to it is, as immigration reform it possibly happens in the next year or so, one of the key conditions of all the immigration reform bills is that the workers have to be paid legally in order to stay in the country. So if they have documented wages for years, it helps their case, and they may be able to qualify as a provisional resident if they have handled their taxes correctly. But
how do you handle the taxes when you don't have a Social Security number?
Well, the worker would have an I-10, which would essentially be an individual taxpayer identification number. So the employer would then fill out all the forms using the I-10, and the IRS will eventually start to write a note saying we need a Social Security number to replace this I-10, but by that time, the family can then just provide the social if the worker has one, or try to just delay the whole immigration process. It's real sloppy right now, the way we handle undocumented workers in this country, and it's one of the things that's kind of being cleaned up in the immigration reform bills. So we will see in the coming year or so whether this becomes easier. But if anyone has a question about a particular worker, I would advise them to call our office, and we can help them through it, or hook them up with an immigration attorney who can help them as well. It's not easy. Okay, I know we're running out of time. I'm going to run through a couple of slides real quick on how to help clients save money. The first one is that there are two dependent care tax breaks. One is called a flexible spending account, and it allows families to pay for up to $5,000 of dependent care expenses using pre-tax dollars. So a family who is enrolled in a flexible spending account can actually reduce their tax bill by $2,000 to $2,300 depending on their marginal tax rate. But it's a very significant tax break that is not income restricted, and it's not subject to AMT. So most of your families will be able to take this. The only restriction that the IRS places on it is that both spouses have to pass the work-related test. So it has to be for so that the spouses can either work or be full-time students. So that's important to know. And it's also important to remember that there's a 30-day window around life-changing events, so that they could enroll mid-year if they have the birth of a child, or they move or switch jobs or anything like that. They actually would be able to enroll mid-year. So as an advisor, you can help them take advantage of that in this tax year and not have to wait until next year. But if they can't get into their flexible spending account this year, or maybe they don't have access to one, then they can still take advantage of the child care tax credit, which does allow you to itemize $3,000 per child with a maximum of $6,000 total. There is a 20% tax credit on those itemized expenses, and so families will save $600 if they have one dependent, and $1,200 if they have two or more dependents. In addition to the tax breaks, there are some ways to structure payroll so that the amount of taxes is reduced for both the employer and the employee. And those non-taxable compensation forms are health insurance. So if the employer contributes to health insurance for the employee, college tuition up to $5,250 per year, cell phone service, public transportation up to $130 per month, and then parking at the job site or at the public transportation facility is non-taxable up to $250 per month. So those are really savvy ways to shelter some wages from taxes, and we strongly advise families to do that and optimize those tax savings. There is also an additional layer of tax savings for families that contribute to the health insurance, and that is the health insurance tax credit for small employers. And then I'm just going to kind of wrap everything up real quick. I know we're out of time. I'm going to wrap it up real quick with just kind of a reminder that the families oftentimes ask, what are the benefits of paying legally? And you know, I try to remind them that they don't, you know, the IRS, the state tax agencies, and even former employees who might file wage disputes, those are risks that most families really don't want hanging over their head. And it's important to know that legal pay is really kind of like an insurance product against any kind of problems related to being an employer. So we really want them to understand how to mitigate risk there, and particularly when you look at it in light of the fact that the dependent care tax breaks will offset most of the costs related to being an employer. It really makes it nonsensical to pay off the books when you look at the dollars and cents there. And then the third benefit of paying legally is that the employee is going to receive benefits and protections such as Social Security, Medicare, and unemployment and disability. Even the ability to get a loan or a credit is really tied to documented wages. So, you know, if you take all three of those things combined, it's really, I think, important for us as advisors to understand that our families, this really is the wise thing to do, is to take care of this correctly and not have these kind of problems hanging over your head. As I mentioned before, we have a number of free resources that you are entitled to use for your practice or your clients. We have booklets that we can keep you in stock for free, calculators on our site, and for both the employer and the employee. We also have, I alluded to this earlier, but really important, we have state-specific requirements on our site in our answers library. So if you're wondering what labor laws and tax laws are in your particular state, we have it all listed there. So feel free to use that as a reference or give us a call. We have a team of experts that are here to provide free consultations for your team or your clients. And our goal is to make this easy for families and take all of the risk and expense out of the equation for you and your family. So please use us and abuse us. Call us anytime. We're here to help. Thank you for your time today. We really appreciate you attending. I don't think we have time for questions, but if you want to follow up, you can send us an email. Our email is homepaypartners@care.com, which is on the bottom of the slide there. Feel free to drop us an email or give us a call, and we'll be happy to consult with you and your families and take care of this important aspect of your family's world and make sure it's easy for everybody. Sid, do you have any final words?
No, I just want to thank them all for joining us, and thank you, Tom, for your lucid presentation.
Thank you very much. Thank you, Sid, for being here, and thank you to all the attendees. I hope you have a great day, and look forward to working with you. Bye-bye.